Good afternoon, everyone. Welcome to the RDS Thursday webinar regarding Worldwide Mareva Injunctions with Mr. Nagarajah, a partner at RDS. My name is Shaun and I'm a senior associate at RDS, and I'll be a moderator for today. For the benefit of our participants who do not know Mr. Naga, he has vast experience in shipping litigation and maritime insurance. He is also actively involved in other practice areas, such as aviation, building and construction, as well as general and civil litigation. Mr. Naga has been in active legal practice for more than 40 years, and he has acted in numerous landmark litigation cases. He was the former president of the Malaysian Maritime Law Association, and he was a former member of the International Pacific Bar Association, where he had presented a number of papers over the years. I believe that we will all benefit from Mr. Naga's wealth of experience and knowledge, and I look forward to an illuminating session today. If you have any questions, please feel free to drop them at the chat box, and Mr. Naga will address it at the appropriate juncture. Without further ado, it gives me great pleasure to pass the time now over to Mr. Naga.
Thank you very much for attending this session today. This is our regular Thursday webinar. And today's topic, we decided, even though it is topical, that is Worldwide Mareva Injunction. But the gist of the session will be very legal. And the reason why we have decided to choose this particular topic, not only it is topical presently, but more than that, we wanted to draw the attention of latest developments in the area of Mareva Injunction. Now, there is an interesting Privy Council decision in 2022 in broader idea. As we go down the slides, you will have the citations, but let me just introduce about this Privy Council decision. This is a decision where Lord Legate questions the validity of the Siskina principle. I don't know how many of y'all are familiar with the Siskina principle, but what I would wish to highlight is that the basic principle of the Siskina is a right to obtain interlocutory injunction is not a cause of action. It cannot stand on its own. It is dependent on there being a pre-existing cause of action against the defendant arising out of an invasion, actual or threatened by him of a legal or equitable right. So what basically it sets out is that there must be a pre-existing cause of action. This is the decision of the House of Lords in England, which basically regulates how one is entitled to injunctions and Mareva injunctions as such, interlocutory injunctions included. Now, I'll take you at the beginning of this session to deal with the elements of Worldwide Mareva. And that is covered in my slide number 2. Slide 2? Yeah. No. Slide 2. Okay. Requirements for a Mareva injunction. In Malaysia, the legal landscape started to take shape with the adoption of the principle set out by Lord Denning in 3rd Chanceries. And the elements are quite straightforward. Firstly, a claimant would have to establish a good arguable case. And number two, the plaintiff must produce evidence that the defendant has assets within the jurisdiction. And number three, risk of the assets being removed from the judgment before the judgment is satisfied. That is the three main basic elements, subject to obviously the requirement that the court have jurisdiction to commence proceedings in Malaysia and or to effect service of the originating process out of Malaysia. Three. Now I'll deal with the issue of good arguable case. This was considered, the test was applied in SRC International Limited against Transcorp. And they adopted the seminal judgment of the House of Lords, seminal judgment of the Court of Appeal in Nemenia Maritime. And what does Nemenia Maritime sets out? I have it set out in the slide itself. Nemenia discusses the test that the court would apply to determine whether there is a good arguable case. Mustil J, quotation, a plaintiff must show first that he has a good arguable case, which is more than being barely capable of serious argument, but not necessarily one that the judge believes has got more than 50% chance of success. If I may pause here, bear in mind that the process of applying for Mareva injunctions are usually interlocutory, and it is done by ex parte in the absence of the defendant, unless there is prior direction from the court that it should be heard inter partes. So the object at the interlocutory stage is basically to decide whether you got a good arguable case. Moving from there, we must satisfy the second element, that is that there is evidence of some assets within the jurisdiction. This is the assets of the person against whom you wish to secure the Mareva order against. And this was considered in the case of Lian Ho Sawmill by Justice Zakaria Yatib, as he then was. And this is what he held. In my opinion, what the plaintiff required to do is to give some grounds for believing that the defendant have assets within the jurisdiction. So the claimant in his affidavit in support for the application for Mareva would have to set out some basis for his belief that the defendant has assets within the jurisdiction. At this stage of the proceeding, generally, the plaintiff would not have a complete list of all the assets, but whatever assets that he is aware of, he should await in his affidavit in support of the application for Mareva injunction. And moving from the second element, we now go on to the third element that the claimant would have to satisfy. The claimant would have to, in his affidavit, set out the risk of dissipation of the defendant's assets if the Mareva injunction is refused. Now, before I go into that, the decision in Customs and Tax Administration of the Kingdom of Denmark case, let me just set out that a Mareva injunction, like a freezing order, is basically to ensure that there are sufficient assets within the jurisdiction that would satisfy a judgment that the plaintiff will eventually sign against the defendant, either at the summary stage or at the trial. And this process could also be applicable pre-trial as well as post-trial. Post-trial in the sense that after you have obtained a judgment and before you carry out your execution or enforcement proceedings, you fear that the judgment debtor or the defendant might dissipate or might move assets out of this jurisdiction, so that in order to frustrate you recovering his possible judgment that he will sign or the judgment that he has already signed. So that is the issue of why we would have to satisfy, the claimant would have to satisfy the risk of dissipation. What is the meaning of risk of dissipation? Now, I will go into great detail on this because this has always been the main issue in any Mareva application. Now, in this particular Court of Appeal judgment, the Court of Appeal held in determining whether there is a risk of assets being removed, lack of probity and honesty can be determining factors in drawing a conclusion there is such a risk of dissipation. Let me pause. Question of lack of probity and honesty is only one of the determining factors, not necessarily the sole factor that one would have to show in order to satisfy the potential risk of dissipation of assets. Now, if I may deal more closely on the issue of dissipation, you remember I dealt with the seminal case of Nimenia Maritime. That is the case that sets out the basic principles in the Court of Appeal. Now, what other decisions, most of the decisions on Mareva would have followed the Nimenia Maritime principle. And I think even in respect of the issue of dissipation, it is important for one to fall back into the decision of Nimenia Maritime, because Nimenia Maritime clearly sets out the principle. And in order to, again, determine what is the risk or what is the factors that you need to show, one would have to bear in mind the purpose of a freezing injunction. The freezing injunction is basically to ensure that the judgment in the applicant's favor will not go unsatisfied by the reason of the assets being dissipated or being dealt in such a manner that will make them unavailable for the judgment creditor. So the importance is one would have to bear in mind that it is essential for the claimant to ensure that these assets are frozen to the limit of his potential claim. If he were to make a claim for 1 million ringgit, he is entitled to freeze assets worth slightly more than 1 million and not more than that, because the idea is to satisfy the potential judgment that he might secure in the course of the trial or after the trial. Now, in Nimenia case, in the Court of Appeal, Justice Kerr was very clear. He said it is not necessary for the claimant to show a nefarious intent on the part of the defendant. That is not necessary. as it is clear as to the intention of securing a Mareva. It's basically to ensure that the judgment will be fully satisfied. And the Niminia case clearly sets out the test. And the test that is enunciated in Niminia is very clear. And it says, one is required to show that the likelihood of dissipation means the risk and not the probability. There is no necessity to show the probability of dissipation. One would only need to satisfy risk of dissipation. In fact, Niminia's test is of real risk is lower than the test of likelihood. I hope that sufficiently explains on the issue of risk of dissipation. And what happens that in most cases, in Mareva injunctions, claimants tend to show that a shell company has been set up by the defendant overseas in foreign jurisdictions, and sudden transfer of funds to these shell companies out of the local jurisdiction. One has to distinguish between normal business transaction, payments that is made in the course of normal business transaction. That would not be considered as part of the risk of dissipation. But just before a judgment is delivered by the court in our jurisdiction, attempts were made to move substantial sums of money out of the local jurisdiction. That might potentially show an attempt, or there is a risk of dissipation. That is one of the factors that is taken into consideration. But then in the case of a defendant who is involved in international business transactions on a daily basis, it's not going to be that simple to argue that whatever payments that is made in the course of a normal business transaction is an attempt by the defendant to dissipate assets. So it is important for the claimant to investigate and marshal his evidence before he goes before the court to apply for a Mareva order or a freezing order. The next requirement, which is not an element per se of the Mareva injunction, but one would have to show, slide 7. One would have to show that the Malaysian courts have jurisdiction, in personam jurisdiction over the defendant. And as I've explained earlier, is either one of the defendants is in Malaysia, but subsequently he has left the jurisdiction, and you are commencing an action to freeze whatever assets that he may have within the jurisdiction. Or he may be resident in foreign countries, and you want to secure a Mareva to ensure that its assets out of the country are frozen. If there are insufficient assets in Malaysia to satisfy the judgment that the claimant hopes to sign or have signed. So it is important to, first of all, establish that the local courts have got the jurisdiction to commence proceedings. In respect of a fact where he is not a Malaysian, but if he is a foreigner, but the cause of action accrued in Malaysia, it would be still be possible to commence proceedings and effect service of the originating process through the rules of court, that whereby you would be able to secure a personal jurisdiction over the particular defendant. Now, the development of Worldwide Mareva Injunction started off with Nemenia Maritime, further developed by Siskina, which basically curtailed or set the pre-requirement for an interlocutory injunction. And in Siskina, Lord Diplock, in fact, commented on the Mareva injunction in the following words, saying it's new and creative. At the time when Siskina was decided, Mareva jurisdiction was still at its infancy, and I believe Siskina was decided within 2 years of the case which established Mareva injunction. So the principle of Lord Diplock in Siskina was very much being developed, or as I said, is in infancy. So we got to view Diplock's judgment in Siskina with that particular backdrop in mind. Of course, the Mareva jurisdiction has broadened in its scope today. One would be able to secure, initially when Mareva was introduced, it was intended to restrain defendants out of the jurisdiction. Subsequently, it has now been extended to even to defendants within the jurisdiction. And pursuant to Mareva jurisdiction today, one would also be able to secure discovery process as to the whereabouts of the assets of the defendant. And you are now able to also secure Worldwide Mareva when the claimant themselves is not very sure where the assets might have been dissipated to. So it has broadened in its scope. But I'll come back to the importance of the requirement that I've highlighted at the beginning of the seminar on the issue of Siskina. Okay, next. No, it's it. No. Slide E. Slide E. What do you do? How do you use it? Yeah. In slide A, we have covered the issue of how the development of Worldwide Mareva took place in UK. We start off with United Kingdom. And in United Kingdom, one of the basic Privy Council decision was the Mercedes Benz against Ledwick, decided in 1996. In this particular decision, what is important or what is relevant is the decision of Lord Nicholas. But unfortunately, he was in the dissenting judgment. But his decision, as we go down further, will show that it is now widely accepted as setting out the present state of the law. And this is what he said in respect of a freezing injunction. If I may just read the quotation of Lord Nicholas, where he said, although normally granted in proceedings in which judgment is being sought, Mareva relief is not granted in aid of a cause of action asserted in the proceedings, at any rate in any ordinary sense. It is not so much relief appertaining to money claims as relief appertaining to prospective money judgment. It is a relief granted to facilitate the process of execution or enforcement, which will arise when, but only when, the judgment for payment amount of money has been obtained. The court is looking ahead to that stage and is taking steps designed to ensure that the defendant cannot defeat the purpose of the judgment by thwarting in advance the efficacy of the process by which the court will enforce compliance. So, as you clearly note from the quotation, as to the position Lord Nicholas highlighted in the judgment, is the Mareva relief is not tied to the cause of action. This is a very drastic departure from the tried principle under Siskina. This is in 1996, and Siskina is still good law and constantly being applied in Malaysia. So the issue is, Mareva relief is not granted in aid of the cause of action asserted in the proceedings, at any rate, in any ordinary sense. So it is basically a relief to aid enforcement. Why this passage is so important is that there have been cases where court was unable to give any reliefs because one was not able to format a cause of action against a particular party. There could be situations where a defendant could have possibly transferred funds to a third party who is holding it for the benefit of the defendant. And how do you secure a Mareva relief against the assets of the third party when the claimant has no cause of action against the third party? And as is common, if anyone would want to dissipate any assets, it would be foolish in any of them to hold the funds in their own name anywhere in the world. So logically, what would happen is they would try to secretation the dissipation. And in this day and age, how they go about in doing it has no bounds. Slide 9. And in slide 9, and I've highlighted Lord Nicholas' view has been accepted in Australia by the Apex Court and slowly being accepted in Singapore, which I will deal with it towards the end of the webinar. And it is also being discussed and considered in the High Court in Malaysia, which I will deal with that as well. Now, if I may go to slide 10. continuing with the development in UK. In slide 9, I dealt with the Mercedes-Benz case, which is basically a Privy Council decision. And that was in 1996. Following from that, in 2007, the House of Lords was given an opportunity to revisit the issue of a freezing order. And that was decided in 2007. This particular judgment did not specifically or expressly analyze Lord Nicholas' analysis in Mercedes-Benz. But notwithstanding that, this is what was highlighted by Lord Bingham. If I may just read what he had said. Mareva or freezing injunctions were from the beginning and continued to be granted for an important but limited purpose: to prevent defendant dissipating his assets with the intention or effect of frustrating. If I may pause, the issue is frustrating enforcement of a prospective judgment. They are not a proprietary remedy. They are not granted to give claimant advance security for his claim, although they may have that effect. They are not an end in themselves. They are supplementary remedy granted to protect the efficacy of enforcement proceedings. So, as you would note, that Lord Bingham was in the majority in Fowrie against Lee Rocks, beginning to accept Lord Nicholas' dissenting judgment in Mercedes-Benz. The question is whether the trend continues. We now move to slide 11. A continuation of the UK development. I think I will not trouble you all with that. And slide 12, Lord Scott, in the case of Foray against Lee Ropes, is that what he went on to establish. He said, from the review of the authorities, Lord Scott drew the conclusion at para 30 that provided the court has impersonal jurisdiction over the person against whom the injunction, whether interlocutory or that is sought, the court has jurisdiction in the strict sense to grant it. As for the manner in which the power should be exercised, and this is interesting, he said the practice regarding the grant of injunctions as established by judicial precedent and rules of court has not stood still since the Skiskida was decided and is unrecognizable from the practice to which Cotton LJ was referring. In North London Railway, I believe that was in 1883, to which Lord Diplock referred to in the Skiskida. So what basically that we can deduce from Lord Scott's observation is this, that when Skiskida was decided, Lord Diplock was still referring to the practice of the court process in 1883 by referring to the North London Railway case. We have moved from, the practice have evolved and moved from the 19th century to the 20th century. We are now in dealing with the issue of worldwide Mareva. So the question is, are we bound by the tribe principle set out by Lord Diplock in Skiskida? that there should be a pre-existing. Is it possible for one to commence an action against a party whom we believe may possibly hold the defendant's assets, but the claimant might not have a cause of action against the defendant? This led to the new concept of non-cause of action defendant. Let me just explain to you what I mean by non-cause of action defendant. There can be situations where you commence proceedings in Malaysia against a Malaysian party, either is in Malaysia or out of Malaysia, and you add a co-defendant who might either be in Malaysia or out of Malaysia. Notwithstanding that the plaintiff might not have any cause of action against the co-defendant. If we apply the traditional Siskina principle, your claim against the co-defendant is bound to fail because there is no pre-existing cause of action against the co-defendant. And that is why the development, or that is why the dissenting judgment of Lord Nicholas in Mercedes-Benz case is so important. And the acceptance of that principles enunciated by Lord Nicholas, acceptance worldwide in the Commonwealth or in common law countries. And an interesting development took place in Malaysia in the High Court. The principle has not been dealt with by any of the apex court in Malaysia. The High Court in digital tempo had an opportunity to make observation in passing, and that is reported in 2021 in MLG. And he dealt in depth the principle laid down by Siskina. And if I may go to slide 14. Slide 14. Slide 14. This is paragraph 42 of the digital tempo case. And his lordship dealt with it in this fashion. He said, in England, the judicial development on interlocutory injunctions in aid of foreign proceedings did not end in the Siskina case. And he goes on further. If I may skip the rest of the paragraph till towards the end. In subsequent House of Lords case in Channel Tunnel Group, the House of Lords clarified the ratio decidendi in the Siskina does not preclude the English court from granting an interlocutory injunction ancillary to a claim for substantive relief to be granted by foreign court or an arbitral body. So, as you see how Mareva has developed, it has developed to the stage where a foreign claimant could possibly obtain a judgment against a Malaysian within our jurisdiction and seek redress from the Malaysian court to freeze the assets of the Malaysian within our jurisdiction, to assist a foreign judgment. If it is in the case of, if it is a case of an arbitration award and in the application of the New York Convention, you would have to apply to register your arbitration award, or you may have to, if it is not an arbitration award, if it is a judgment of a high court where the Reciprocal Enforcement Act is applicable, you would still have to apply to register the foreign judgment. But what the development in Mareva has enabled is one would not have to wait to try and freeze an asset in Malaysia which the foreign claimant might be entitled to execute against that particular asset. So that is an important development in the field of Mareva injunction. So it's not necessarily to aid a Malaysian judgment, but it also might be important to aid a foreign judgment. And His Lordship in this paragraph cited the dissenting judgment, which is not referred to in this passage, cited the dissenting judgment of Lord Nicholas in Privy Council in the Majlis Bands. And he said it was held that since there was no reason in principle why a claimant could not enforce a foreign money judgment in the BVI courts, there seemed no logical reason why he should not be able to make a claim for ancillary relief to a foreign award or judgment, such as a freezing injunction. So this gives us a clue of how the legal landscape in Malaysia might possibly change. And I'm confident that the development of Mareva and Worldwide Mareva will continue to develop in common law countries as well as in Malaysia. Moving from that, if I may take you all to slide 16. In the High Court decision in Singapore, Sulzer Pump Spain against efflux membrane manufacturing, this is only a High Court decision whereby the learned judge distinguished Siskina and also distinguished Singapore's own Court of Appeal decision in B. Ziaoqing. Hopefully I pronounced it correctly. This is a Court of Appeal decision in Singapore which applied in respect of freezing, in respect of Mareva, and in relation to, and applied the principles of Siskina. What the High Court judge in 2020 did is to distinguish even the Court of Appeal decision. And this is what he said about the Court of Appeal decision. He said, applying Fowry, which remains useful to show that the court has equitable jurisdiction to issue freestanding injunctions, even when there is no cause of action. Further, B. Ziaoqing relied on Siskina, but did not consider Fowry, which was the more recent House of Lords decision, which departed from Siskina. So, in attempting to set a new trajectory in the development of Worldwide Mareva Injunction, the learned judge in in Salsa Palms, distinguished B is your king. Now, coming to the latest case that I wanted to draw your attention, and this is the case of Broad Idea, Privy Council decision case in Broad Idea, decided in 2022. This case finally establishes the principles set out by Lord Nicholas in Mercedes-Benz as the state of the law in their decision. And Mercedes-Benz goes on to deal with the issues in detail. I would not wish to take you all in great detail, but let me explain to you all the significance of the case. The significance of this principle, which is firmly established by the Privy Council, is that you got to read Siskina with circumscope, and it opens a new line of causes of action that one would have, or new line of securing a Mareva relief against a non-party, thereby establishing firmly a non-party defendant, non-cause of action defendant. Or freezing order against a non-party who is resident out of the jurisdiction, or even within jurisdiction, against whom the claimant itself does not assert direct claim for substantive relief in respect of assets that are situated both within and outside the jurisdiction. Why is it so important for the development of commencing a non-cause action against defendant? Is basically to ensure that whatever judgment that the plaintiffs might secure will get satisfied. So what you need to do to establish that the non-cause of action defendant holds some property or some assets for and on behalf of the defendant against whom the claimant firmly established a cause of action. So that shows the trajectory of the development that is taking place in the Commonwealth as well as in Malaysia. And with that, I believe we have come to the end of the webinar. And if any one of you all have any questions, please don't hesitate to put forward to us, and we'll attempt to answer. Thank you. Shaun, can you take over?
Yes, thank you, Mr. Naga, for the illuminating session. I think we have certainly learned a lot about the developments of the Mareva Injunction. I take it that our participants may have some burning questions, but I don't see any at the moment. Please feel free to drop it in the chat box, and we'll try to address them as soon as possible. But since we have some time, perhaps Mr. Naga, if I could ask you a question. I take it that you agree with the developments in the Commonwealth countries. You agree with...
Shaun, I can't hear you that well. Can you speak louder a bit?
Sure, certainly. I take it that you agree with the recent legal developments of the principle of Mareva Injunctions. Would you say that it has developed appropriately, or do you think we should still stick to the Siskina principle?
I believe the development, I don't think we have seen the end of the development. It's a continuing evolving process. And from the time we started with Siskina and Lord Diploc's comments on the Mareva jurisdiction, and how far we have come clearly shows that Siskina has not been able to curtail the development of the Mareva jurisdiction. What broad idea offers is that for an potential development of the principle, to ensure that the basic requirement or the judgment that is signed by the claimant would not go unsatisfied. That would be basically the main issue.
I see. Thank you for that.
So
yeah.
As long as we remember the purpose of Mareva, it is not that you are seeking an attachment of the asset, even though the effect of it is the same. It is not that you are taking priority over the assets against others who might possibly make a claim to the same asset. It's basically a form of security to ensure that your judgment is satisfied. I hope that answers your question.
Yes, certainly it does. Thank you, Mr. Naga. It looks like our participants do not have any further questions. I believe they have all benefited from the knowledge that you've given us today. And I think you've adequately
Shaun, I must admit that it's quite a legalistic session.
Yes.
It was intended to serve that purpose, intended to draw the attention of the participants to the new developments in law and the potential it poses. Over the years of practice, I've seen many judgments remain unsatisfied and considerable expenses have been incurred in order to secure those judgments, but to no avail. So I believe the Mareva relief will give assurance to claimants who legitimately believe that they have been aggrieved.
Right.
So in that sense, it's important. In that sense, we don't know where the development will continue, and we will see a lot more issues being raised.
It sounds like a very exciting time for the development of law. I too look forward to what will happen in the future. It seems like a lot of businesses will benefit from this as well to secure their interests.
Thank you.
Yeah, I think there's no further questions from the audience, so perhaps we could end the session now, if that would be okay, Mr. Naga. All right, thank you everyone for participating.